We've created this video to familiarize employers with the basic obligations regarding safety at work, aiming to improve health and safety protection in the workplace. Each and every employer in the Republic of Croatia, regardless of their activity or size, is obliged to organize and implement safety at work. It is in the interest of every employer to protect the working ability of employees as well as the legal business. The minimum requirements regarding health and safety at work are prescribed by the binding acts of the European Union, adopted conventions of the International Labour Organization, and equally laws and bylaws adopted in the Republic of Croatia. Investing in protecting the health and safety of employees is of great interest to the employer, as injuries at work can cause large direct and indirect costs that simply could have been avoided. By implementing effective safety measures at work, risks at workplaces are reduced to the minimum, and so the employer significantly contributes to the stability and safety of its business. There are three main reasons why the employer implements safety at work. Number one, moral reasons. They arise from our moral duty to help one another. Undoubtedly, there is a need for employees to protect themselves from injury and illness when they are at work. When safety at work is not implemented, it has negative consequences, not only for the employer and employee, but for the entire families, friends and colleagues. This is morally unacceptable, and therefore every employer is expected to implement safety at work. Number two, legal reasons. Actions by the employer contrary to prescribed obligations, which have resulted in the injury of an employee or a person working for the employer, or their occupational illness, leads to a misdemeanor and criminal liability of the employer. This cannot be an acceptable business risk for any employer. Number three, financial reasons. Every injury or illness at work costs money. Injuries at work have direct and indirect financial costs. Direct costs are related, for example, to compensation for damages and fines resulting from the employer's misdemeanor liability, and indirect costs are related to the loss of reputation, loss of contracts, cancellation of orders, etc. The key principle in safety at work planning is prevention. The goal of safety at work is not to treat injuries and put out fires, but to prevent all of this, so that employees return from work alive, uninjured and healthy. There are two types of preventative measures that we can take regarding safety at work. Number one, engineering or technical measures, whose goal is to act directly on the source of risk in order to remove, reduce or replace that risk. Such a technical measure could be, for example, dust suppression, using water to prevent exposure to dust or a local ventilation system. Number two, organizational or administrative measures, whose goal is to change behaviors and attitudes and promote a positive safety culture. Safety culture certainly affects business competitiveness and maintaining stable ties with business partners to continue long-term business cooperation. Essentially, if the employer successfully manages the risks related to the protection of health and safety at work, we can then expect no unforeseen interruptions and disruptions of production or business processes caused by accidents or injuries at work or adverse effects on the working environment. Such disruptions in work processes can easily threaten the business, not only for the employer, but equally business partners if they have to wait for their ordered parts or services. Employers are responsible for quality occupational safety management. The law mandates that risk to the health or safety of employees must be adequately controlled and that appropriate measures must be taken in order for the work process to take place without threats to the life and health of employees. The occupational safety system that the employer is obliged to provide in accordance with the Safety at Work Act obliges the employer to ensure the following: to regulate the manner in which safety at work activities are organised and carried out in accordance with Safety at Work Act and the Ordinance on the Performance of Occupational Safety Activities. To create a risk assessment available to employees in the workplace. The risk assessment is a fundamental document of safety at work in which hazards are identified for all jobs. Risks are assessed and an appropriate plan of measures is defined in order to keep these risks under control. Employees, their representatives, authorised persons and occupational safety experts must participate in the risk assessment. To draw up an evacuation and rescue plan, which all employees will be familiar with, and to conduct practical evacuation and rescue exercises based on that plan at least once every 2 years. To implement the ban on taking addictive substances, that is, to ensure the protection of non-smokers and to prevent smoking, and to implement the ban on the abuse of alcoholic beverages and addictive substances with suitable measures. To ensure that only employees who have received written instructions for working in a safe manner and appropriate personal protective equipment have access to workplaces where jobs with special working conditions are performed. With regard to injuries at work, the employer should notify the body responsible for inspection immediately after the occurrence of a fatal injury. The same applies for an injury that occurred in the room where an employee was given emergency medical assistance and where the injured person was kept for treatment in a stationary health institution or a day hospital. Additionally, if the employer employs 50 or more employees, it is mandatory to organise a meeting of the Occupational Safety Committee at least once every 6 months. In the case of a fatal injury, the session of the Occupational Safety Committee must be convened within 2 working days of the occurrence of such injury. Failure to fulfil these 7 obligations is directly punishable, and in addition to the fine paid by the company, there is always a fine for the accountable person of the company. In addition to these obligations, there are also the following obligations that are not directly punishable but are extremely important. The employer should carry out testing of the work equipment periodically within the prescribed deadlines. This refers to the testing of work equipment, electrical installations, lighting protection systems, etc. Testing of perimeters of the working environment must also be carried out within the prescribed time limits. This involves measuring lighting, noise, microclimatic factors, and the concentration of chemical hazards where they occur. This is usually performed once every 3 years. The employer must provide first aid in the prescribed manner. In addition to the appropriate equipment, he must ensure that in the area where 2 or more workers perform their duties, at least 1 person is trained to provide first aid for every 50 workers. The employer must provide adequate work instructions and safety signs in the workplace in areas where risks can be avoided or adequately reduced. Regarding employee training, the employer must provide training for employees to work in a safe manner, training for the employee's authorised representative, and training for the employee's representative. This training is conducted by occupational safety experts, experts employed by the employer or experts employed by authorised persons. Evidence that the worker is adequately trained to work in a safe manner is represented by a record drawn up on a prescribed form. And finally, the employer should provide each employee with health care appropriate to the risks for health and safety. In other words, appropriate medical examinations that are carried out in occupational medicine offices. Failure to fulfill the second set of obligations does not result in a direct fine, but we could say they get a yellow card, i.e. the employer receives a deadline until a certain obligation must be fulfilled, with the threat this time of a significantly larger fine. Let's also mention that in the case of an inspection for emissions related to the examination of work equipment and the working environment, the sanctions for inspection include the sealing of the work premises and work equipment. In the case of injuries at work, failure to fulfill all these obligations may result in the initiation of a criminal complaint, which is much more unpleasant for the employer than a one-time payment of a fine. The key is that there is no insurance policy that the employer could pay for, which would prevent him from criminal liability in the event of an injury at work. Therefore, the employer should understand that protection at work is an extremely serious matter and not another scheme imposed by the state in order to collect more taxes. It's in the interest of the state to implement safety at work, as injuries at work can have strong consequences, such as reduction of human resources, increased state expenditures for the cost of treatment, rehabilitation and sick leave, increased expenses due to early retirement, various social expenses that occur as an indirect consequence of injuries at work. Safety at work must not be a formality, and its implementation must not be underestimated. Every employer must develop a positive work culture and implement a quality system of occupational safety rules in their work processes. And this is an important factor within a successful business. Fewer injuries mean fewer lost working hours, which means more productivity. Failure to implement safety at work and failure to take preventative measures can, with its unwanted consequences, threaten the business, stability, and even the survival of every company, especially smaller ones, as the costs that arise due to injuries at work and inspection fines far exceed any investment in prevention and safety at work. Precisely for these reasons, safety at work should be the priority of every employer.